This is Vickie Deppe, editor of the State Legislators' Article 5 Caucus newsletter. We're back with our sixth and final installment in the Article 5 primer series, Can an Article 5 Convention Run Away? Have you been wondering about this? Let's dig in. There are people who oppose holding an Article 5 convention of any kind. They don't care what the subject is, whether it's campaign finance reform, term limits, federal spending. They don't want a convention to happen, period. We refer to these people as naysayers. They argue that such a convention could become a runaway. In other words, the delegates could scrap our entire Constitution and start over. One of the most frequently employed devices naysayers use to scare people is referring to an Article 5 convention as a con-con. In other words, a constitutional convention. Of course, the last time we had a constitutional convention, it was, in fact, to draft our Constitution. And that's what they want you to think will happen if an Article 5 convention takes place. Let's dispense with this scare tactic. It doesn't matter what you call the convention. What matters is where the authority to call it comes from. If it's convened under the authority of Article 5, the only thing it can do is propose amendments, period. Naysayers also maintain that we can't possibly know what will happen at an Article 5 convention because it's never been done before. Though we haven't yet held an Article 5 convention, the states have in fact held interstate conventions over 40 times throughout American history, as recently as 2017. Every one of these conventions has operated according to its mandate, including the Constitutional Convention of 1787, and the 7 general conventions at which anything was on the table. At each of these conventions, the delegates never started from scratch or made things up as they went along. They relied on established precedent such as English common law, international diplomatic protocols, Thomas Jefferson's Rules for the Senate, and Mason's Manual of Legislative Procedure, the very same resources that form the basis for the rules governing legislative bodies today. Those who claim that we can't possibly know what would happen at an Article 5 convention either don't know their history or they're hoping you don't. Every governing body in America, from local school and library boards all the way up to the United States Senate, has rules that prescribe its activities. These rules cover everything from forming committees to notice of meetings to how votes are taken to who gets to talk and when they can talk. None of these bodies avoids forming a new committee out of fear that its members are going to run amok. So, for example, if the library board in a growing community is interested in building a branch library, they could form an ad hoc committee to explore that. The committee might be tasked with things like recommending a location, determining the cost, identifying options for financing the project, and maybe alternatives like a bookmobile program. But no one says, no, don't form this committee. Who knows what they'll do? We know exactly what they'll do. They will operate according to the rules that govern the library board, and they will carry out the tasks they've been given by the library board. This kind of work happens every day in governing bodies, large and small, all across America, and it happens in an orderly manner according to rules and procedures. There's no reason to think that an Article 5 convention will be any different. We'll be covering rules and instructions for delegates to an Article 5 convention at Academy 3.0 in Denver on July 31st, 2022. If you're a state legislator or a member of the legislative staff, you can click on the link below to register. If you're a student of government or you missed the Academy, the link will take you to a recording of the event. What the naysayers hope you won't notice about their narrative is the implication that the only people they think are responsible and trustworthy enough to propose constitutional amendments are those who roam the halls of power in Washington. That the same people who struggle to earn a 30% approval rating are somehow more noble or intelligent than the members of our state legislatures. They seem to have forgotten that most members of Congress were state legislators before they came to Washington. Members of Congress can propose a constitutional amendment anytime Congress is in session. They have done it over 11,000 times, yet no one's raising the alarm about that. Why not? Because they are governed by the rules of their chamber and the constitutional requirement that amendments must be ratified by 3/4 of the states before they can become part of our Constitution. The same constitutional strictures that govern congressional proposals govern an Article 5 convention too. What would you like to see change in Washington? Pork? Corruption? Injustice? The Constitution provides state legislatures with the power to impose reforms on Washington when Congress can't or won't act.